name is Kimberly and welcome back to our channel. Today we are in Białystok, Poland at the Law and Mediation International Conference, and we have some clips for you from mediators and experts and lawyers all across the world.
Thank you very much. Now we're going to Italy, and we'll hear Raffaella Pileri, who is an attorney from Italy and a trial lawyer for over 20 years. She is the founder and managing partner at Mediation&Law, a mediation center accredited by the Italian Ministry of Justice since 2012. Raffaella has been practicing mediation since 2010 on a daily basis. Lecturer and trainer for professional accredited mediators, she teaches ADR and negotiation of international contracts in Italy and abroad. She studied mediation at Pepperdine School of Law and negotiation leadership at Harvard Program on Negotiation. She is the author of articles and books on mediation and negotiation, and she is a passionate to mediation competition and is an experienced judge. Thank you very much for being here, and thank you for sharing the Italian experience of mandatory mediation. It's been already 10 years though, right? Perfect. Thank you so much. The floor is yours. I'll just switch to your presentation. Okay?
Thank you very much for inviting me. I feel all the responsibility of being here talking about the Italian mediation model. Wow, it sounds a very big word, Italian model word. Let's go back to when it all started. We all know we're in Europe. Thanks very much for the experience our speaker from the United States shared with us. We are in Europe as a European member states. We all know the directive, the 52 directive that goes back to 2008, where the European institution introduced the obligation for the member states, European member states, to enact a legislation which introduces in each member state ADR and mediation in particular, because in Europe we do have a tradition of conciliation that goes back to years and years. I mean, if we think about small villages all over Italy or Europe, you might have, mediation and conciliation carried on by the local priest, for example, which is not what we are actually talking about, because when we talk about mediation, we talk about professionals, mediators who manage this particular procedure, which is mediation. As I learned at Pepperdine and at Harvard, negotiation is not just, something we do out of common sense or talent. It's something that must be mindful negotiation. You must be aware of what you're doing as a negotiator. Strategies, techniques, skills, strategies about making offers. I was curious about the concept of honesty in negotiation. Well, we studied negotiation and we all know that there are strategies. First offer between or amongst the reasonable offer or the ZOPA and you make decisions, strategic decisions on how to carry out a negotiation. And who's the mediator? The mediator is the professional neutral who, being a professional negotiator, helps the parties to reach their ZOPA, the zone of a possible agreement, and find their agreement. As a mediator, I don't really care where the parties find their solution. I'm a lawyer. As a lawyer, my mindset is always, to evaluate the case, to evaluate, claims, both claims, and think about it in terms of law, who's right, who's wrong. As a mediator, I don't really care about the right agreement, because it's my view, it's my point of view. If we talk about the interest of the parties, they will find the right agreement. So, going back to the directive, in 2008, the directive invited the member states to enact mediation legislation, and gave the states 3 years to implement the legislation on mediation. Why? Why the directive pointed on mediation mechanism? Because the goal, as Article 1 of the directive said, the goal is to find a balance between mediation and judicial proceedings. Why? Because this is the criteria that would save costs in terms of judicial proceedings, in terms of economy, because mediation has been proved that, and conciliation has been proved that helps the judicial system to work better, to be more efficient, and the economy to save money, so to grow the economy. Next, please. So after many years, we're talking about, we said 2008, and Italy enacted the mediation decree in 2010. Was one of the first new legislation on mediation. And we decided, the Italian legislator decided to introduce mandatory mediation as a precondition to go to trial in several subject matters, like banking and insurance contracts, inheritance, lease, and some others. What happened was the introduction of mandatory mediation and the obligation for the parties to go through an entire mediation process was opposed by lawyers, judges, people, because they were kind of, first of all, there wasn't the culture of mediation at all, because the first obstacle we all encounter is awareness of what mediation is. So, as lawyers, as judges, we are not taught in universities about ADR in Italy and in Europe in general. I'm talking about. So, the introduction of mediation as a tool to actually reduce the caseload of the Italian courts, unbearable, which was and still is unbearable, was a choice that the Italian legislator made, not so much because he was so in love with mediation, but because we really needed to lower the caseloads of lawsuits in courts, because courts, because law justice means no justice. So what happened that in 2012, the Italian Constitutional Court ruled that the decree would be abolished because not because of the mediation system being against the constitutional principles, but because it was a mechanism introduced by a decree, not by an act of parliament, right? So what happened? When we faced this suspension of mandatory mediation, the cases dramatically dropped. from like 200,000 mediation per year to 2,000, 3,000 mediation. So that's why we talk about the Italian model, which is the new model introduced in 2013. Because we realized that we really needed mediation, but we had to find a way to meet the interest of and the right of people to access justice at a right cost, because mediation will cost, I don't want to say a lot, because I'm not talking about Italian mediation fees, because are pretty low and still are, I mean, reasonable. But at the time, one of the main, the main criticism was about a limitation, a constitutional limitation of the right to access justice because of money. So what happened? The new law, enacted in 2013, introduced a mitigated mandatory mediation obligation. So parties, well, the plaintiff who wants to file in court a lawsuit in just some subject matters has the obligation to file a mediation request before a mediation provider, which is always a mediation center, because in Italy mediation is allowed, but only as a profession, only through administered mediation. Why? Because there is this link between very strict connection between mediation and trial, because mediation is a precondition to lawsuit, to file the lawsuit. So you understand the importance of having the Ministry of Justice, having the mediation business and market under control. And also because the Italian legislation introduced a very strong provision regarding the enforceability of the mediation agreement. The mediation agreement is enforceable straight away as long as lawyers sign the agreement to guarantee that the agreement is not against rules and the public order, right? Another provision very important to all of us, because we are lawyers and I still practice law, and the Italian legislation makes the mediation advocacy, so the assistance of lawyers, mandatory. Parties must come to the mediation table with their lawyers. So I know it sounds a bit strange to other mediation cultures, but that's what we as lawyers, as maybe our lobby, obtained in terms of legislation. As a mediator, I'm very happy to have lawyers at the mediation table, because as a mediator, I cannot practice law because I'm impartial, I'm a neutral. I cannot tell a party, say for example, as a lawyer, I realize that one party is waiving his right because he doesn't know the law, because he's sitting at the mediation table without a lawyer. I cannot tell the party, look, you're waiving your right because I'm a mediator. I would violate the impartiality rule. So I'm very happy to have lawyers sitting at the tables, and as a mediator, I do mediate, well, all mediators do not only mediate between parties, but mediate with lawyers, mediate in the relationship between party and lawyer. And talking about building relationship. What do I do as a mediator? I build relationship with lawyers. I build relationship with parties. And I'm very careful about the relationship between lawyer and party. I never ever interfere because lawyers can be, lawyers are very important for the mediation to proceed towards the agreement. If a lawyer is not considered, or even worse, if the mediator was in conflict with the lawyer or tell the lawyer before the clients, you're saying something wrong in terms of law, you're done. Mediation ends. So a mediator is like an elephant among the crystal glasses. It is. You gotta be very careful about what you say or don't say, and make all the parties involved, lawyers and parties, to help parties to find their agreements according to their interests and protect their rights at the same time. So the Italian model was considered a model to follow by the ex-president of the European Parliament at the time. She sent a public letter to the Italian Minister of Justice congratulating about this model, because this first session, preliminary or information session, is very cheap for the parties. And we adopted this mitigated mandatory mediation system, meaning, yes, it's mandatory to try mediation and attend this preliminary first session, but then the procedure, as it is, as mediation is a voluntary process. That means that parties, anybody, can say anytime, thank you very much, I don't want to go further, the opt-out system, I don't want to go further, and that's it. And the preliminary conditions to file the lawsuit will be satisfied. If the plaintiff do not try mediation first, do not file the mediation request, or the defendant show up at the preliminary session, the first session, there are sanctions, procedural sanctions. But why the title of my speech is nudge. It's not an obligation, it's a nudge. And well, I'm about to finish. I'm sorry I couldn't follow my slides because I'm not very much into PowerPoint presentation. And why we talk about nudge? Because it's a mitigated obligation, so it's a gentle way of pushing horses to the lake. And the lake might decide, once they know what we are talking about, how the lake, what's the lake look like, mediation, they can decide if they want to drink water or not, but water must be of a good quality. Thank you very much.